However, we ask that if the court is not willing to do so, that the court exercise its authority under 4035-306 and allow Mr. Henderson to serve 1 year of a sentence with split confinement, where he will get credit for the time he has already served, do approximately another 6 months, and then have the remainder of his sentence suspended. There's no statutory authority that prevents him from being sentenced under split confinement, and we ask that the court allow Mr. Henderson the opportunity to build on what he has already taken his own initiative to do with regard to his sobriety, to continue on with that sobriety, and possibly live out the rest of his life as making amends for his past wrongs, which he has acknowledged. He has an ex-wife that he hopes to reconcile with, and obviously, as the court heard today, he has some children he needs to reconcile with as well. So he asks that the court grant him mercy. He asks to be permitted to serve. He asked for credit time served, but the court has already acknowledged that the court wasn't willing to do that, at least without hearing more. I don't know if Mr. Henderson has pushed the ball in any particular direction, but I think at a minimum, a split confinement sentence is appropriate in this case.
Anything else, Mr. Willoughby? All right. As I said before, it's rare that I will interject myself into an agreement that the state and the defense had arrived at, but this is a different scenario. Most of the time, these plea agreements are made because parties get together during discovery, and that's what that takes place. And before any entry of judgment takes place, they come to an agreement, and I always tend to defer to the state and to the defense because they know their case better than I do. They know the pluses and minuses, and they know that you're always taking a chance with a jury. This is a different kind of case. In this case, as is often the case, someone entered a plea, Mr. Henderson entered a plea to specific offenses. He pled guilty to these offenses and required or requested a sentencing hearing. For that reason, it is, while the state can make recommendations, it is this court's obligation and part of my responsibility at a sentencing hearing to set the sentence that I think the defendant deserves and is justified under the facts and the law. And for that reason, I took the position that what was suggested to me, in my opinion, after reading through the pre-sentence report, was not an appropriate sentence for the type of situation that we had in these three cases. So, in any event, this case comes before the court. The court's required to follow the law. I cannot just set a sentence that I think I want to. In other words, I can't just pick a number and say this is what I think the defendant ought to get. I'm required to follow the sentencing considerations and guidelines that are set forth by our state legislature in the Tennessee Code. Those sentencing considerations are set forth in 4035-103 of the Tennessee Code, and they include the following. To implement the purposes of this chapter, the following principles apply. 1, sentences involving confinement should be based on the following considerations. A, confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. I counted up the number of prior convictions, many of which are traffic related, but they are nonetheless examples of the defendant failing to abide by society's standards of law. And therefore, I do find that there is a lengthy history, a long history of criminal conduct. B, confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrence to others likely to commit similar offenses. 3 of these cases involving aggravated or attempted aggravated assault, and that was an agreement. They reduced the charge down from aggravated assault to attempted aggravated assault. So Mr. Henderson's already had the benefit of his lawyers arguing on his behalf and the state's giving him the benefit of the doubt. But I would simply point out that in the indictment that led to those 3 attempted aggravated assault cases, there were 3 counts. Counts 1, 2, and 3 were actually aggravated assault while displaying a weapon. Count 4 was possession of a firearm. Count 5, 6, and 7 were reckless endangerment, all felonies involving a deadly weapon. And count 8 was possession of a weapon while under the influence. The state, and I understand why, they agreed to dismiss counts 4 through 8 in that indictment and let him plead to simply 3 simple attempted aggravated assaults. So it would not be accurate to say that Mr. Henderson already has not received the benefit of an advantage in the fact that those charges were reduced and many of them were dismissed before it came to the sentencing hearing. C under the statute, going back to the statute, measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. Clearly, he has a long history of probation. He has a long history of the fact that even though he received probation, or a slap on the wrist, if you want to say that, then under those circumstances, he, in this court's opinion, didn't learn his lesson. I know he's saying now that he's learned his lesson and he's going to quit drinking. Well, all I can say is that he's a little late coming to that conclusion with, by my count, 40 or 41 convictions, all of which probably were included or caused by his consumption of alcohol. Sentence imposed should be no greater than that deserved for the offense committed. Inequalities in sentences that are unrelated to the purpose of this chapter should be avoided. The sentence imposed should be the least severe measure necessary to achieve the purposes for which the sentence is imposed. The potential or lack of potential for rehabilitation or treatment of the defendant should be considered in determining sentence alternatives or length of term to be imposed. Trial judges are encouraged to use alternatives to incarceration, which include requirements of reparation, victim compensation, etc. So those are the sentencing considerations that I am required to consider, and I have considered those, as I've stated, in doing that. As was pointed out, he has been convicted of a Class C felony, which carries 3 to 6 years. That's the possession of a firearm by a convicted felon. Each of the attempted aggravated assault.
That hearing had a little bit of everything. Judge David Wolfe presided over the sentencing of Eric Henderson, and while defense counsel pushed for mercy and a creative split confinement option, the judge made it clear this case required a firm hand under Tennessee law. Ad pled guilty to 4th offense DUI, 3 counts of attempted aggravated assault, and possession of a firearm by a convicted felon. His attorney argued that Henderson had shown initiative in pursuing sobriety, asking that he be credited with time served and allowed to serve only a year in split confinement before the balance was suspended. The defense emphasized his age, his hope of reconciling with family, and his apparent sincerity in wanting to live out his remaining years making amends. Judge Wolfe, however, methodically explained why he couldn't just pick a number or defer to the parties' recommendation. He cited the sentencing guidelines in Tennessee Code 4035-103, noting several factors: Henderson's long criminal history, 40 or 41 prior convictions by the court's count, his repeated failures on probation, and the seriousness of the current offenses, which originally included aggravated assault with a weapon, reckless endangerment, and possession while intoxicated before they were reduced. The judge acknowledged Henderson's claim that alcohol fueled nearly all of his offenses and that he now promised sobriety, but observed it was a little late coming to that conclusion after decades of repeat conduct. Wolfe pointed out that probation and lenient alternatives had been tried frequently and unsuccessfully, and that confinement was necessary to protect society, avoid depreciating the seriousness of the offenses, and deter others. His tone was steady but firm, recognizing Henderson had already benefited from reduced charges while still stressing that accountability was non-negotiable. Henderson himself was respectful, quiet, and deferential, but the judge's ruling underscored that sincerity alone couldn't outweigh such a long record. The overall courtroom atmosphere was serious and deliberate, with defense counsel pushing for leniency, the judge rooting his decision in statutory requirements, and Henderson standing as a reminder of how long histories shape sentencing. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.